That is our nature as human beings. We're tinkerers by nature. And as a result, we are also very greedy as humans. We want to protect those things that we create.
Top leaders, meaningful conversation, actionable advice, bulldoze complacency, ignite inspiration, create impact. Produced by the Southwestern family of companies. This is the Action Catalyst.
Are you interested in advertising with the Action Catalyst? Our listeners could be hearing about your brand right here, right now. For details, shoot us an email at info@theactioncatalyst.com.
Today's guest is Andrew Cooper, a top attorney in his field, having led several legal teams for UPS, served as an intellectual property analyst for Coca-Cola, and now serves as the legal coordinator and head of patent acquisitions for Meta. His book, The Ethical Imperative: Reading with Conscience to Shape the Future of Business, is out now.
Andy, I'm Stephanie Moss. How are you?
I'm well. How are you, Stephanie?
I'm good. I'll ask that super open-ended question. Start at the beginning and tell me a little bit about you and your super interesting journey.
Sure. So I am from a small town in South Carolina called Walterboro. If you are traveling down 95, you will pass right by it. I had no idea, no concept of what intellectual property was or even the practice of law until I was in high school, and my father brought home a movie called Separate but Equal, and I became exposed to the law and what lawyers can do, and that began kind of my curiosity to the practice of law. I ultimately went to college in Washington, D.C., and grad school in Atlanta, Georgia at Emory. While at Emory, I did a few internships, one with the Coca-Cola Company, and that's really what started me down the path of IP, really exposed me to the concept, speed of innovation. And for companies like Coca-Cola, innovation is key to them staying at the head of their industry. And it should be something that small business owners think about as well. After leaving Coca-Cola, I went to practice law at Shook, Hardy & Bacon in the patent litigation group, moved from there to UPS. I was a vice president of UPS, the chief IP counsel there, and worked for UPS Airlines. So my UPS history was about 7 years. And then I transitioned from UPS to Meta Platforms, which is where I am now. And I am the head of patent acquisitions. I also do technology transactions, open source, and AI work for Meta and Mark Zuckerberg.
So not a bad journey from a boy from
Walterboro. Yes, Walterboro, South Carolina.
Population of
5,000.
Oh my gosh. Okay, so Walterboro to Okinawa. Tell me about that.
Oh, yeah. So I didn't even touch on Okinawa, but yes, when I was around 9 years old, my dad was stationed in Okinawa, Japan, U.S. Marine Corps. And so we moved to Okinawa, Japan. We were there for 4 years. A lot of my formative kind of relationships and formative years were there in Japan. We stayed on base, went to Department of Defense schools, and opened my eyes to the importance of working with people from all walks of life, all backgrounds. That core value, I think, in organizations today is really important. I also talk about this in the book, the importance of building open systems. That's organizations that are able to assimilate information from various centers of innovation and to incorporate those really quickly into products and services. The organizations that we build today in the United States tend to be hierarchical. They tend to be pyramid structures. Better organizations, future organizations should be more like a biological cell where you have lots of information coming in and being assimilated and worked through and finally incorporated into the organism. And those things that are bad, you kind of kick out, and those things that are good, you make a part of the system. And that really, I think, started my journey in thinking about open systems, diversity and inclusion, and how to make organizations stronger.
What a very real experience. Now, if you don't mind, I'm going to ask you to kind of educate us a little bit. Walk me through this idea of what is intellectual property.
Yeah, absolutely. So intellectual property is really the intangibles around your business that make it what it is. So when you think about a name, a brand, human generated content. These are things, anything that comes out of the mind of humans can be protected in intellectual property, anything that's affixed in a medium. So if you are an artist and you conceive of an artwork or design or a painting and you put that onto canvas, that can be protected. Companies, I know small businesses, big businesses, they tend to focus on products and services. They tend to focus on what am I selling and protecting what I'm selling. But behind that are rights that need to be protected. And when they're not protected, you run into issues where people can steal and people can copy. So IP is integral. It's part and parcel of running a good business. So when I worked at Coca-Cola, one of the very first cases that I had to work on was an inventorship dispute. And at issue was a patent, a novel gas barrier additive that Coca-Cola included inside of its plastic bottles that extends the shelf life of carbonated drinks. So if you come up with this amazing container that can keep sodas really fizzy for a long period of time, that would be protected by the idea of patents. On the other side of that, you have trademarks, and trademarks are really, really powerful because they indicate source of something. A really strong trademark is Apple, for example. So an apple, it's a fruit, right? But in the context of technology, Apple is a company and a company that makes really great products. And anytime someone sees the Apple logo or they see the word Apple on technology, they know where it comes from and they associate a level of quality with it. So trademarks are really important. And when I was chief IP counsel of UPS, one of the largest assets that sits on the book of business are the brands, the logos, slogans that indicate the source of the good, because there's enormous goodwill that comes along with it. Some lesser known but really, really important forms of IP today include copyright. With the advent of artificial intelligence, these AI systems are trained on content, and content is generated primarily by people. And so if you were an author and you write a book, that content is protected by copyright. And so to prevent others from taking it and using it in ways that you would, object to, it's important to protect those things. And companies do these, they create white papers and research and things like that all the time. So it's really important to protect that. Probably the least known and least used form of intellectual property is trade secret. And trade secrets can be so powerful. They're know-how. They're confidential business information that gives you a competitive advantage that other companies don't have. So if you are a small business and you have a way of collecting data and you hold that data and no one else has that specific data set, or a way of doing something that is better than the way other people do it, that's a form of knowledge, of intellectual property that can be protected.
So if you have a sales process that is common practice in your industry, that doesn't really fall under IP.
That's right.
But if you have a process that's unique to your firm or organization,
could be a trade secret. It's you have a sales process that's different and unique and provides you a competitive advantage that other people don't have. You can protect that as a trade secret.
Okay. I know right now it's kind of hot on the docket, this idea of getting rid of non-competes and non-solicitations.
Yes.
So you don't typically hear IP being protected in non-solicits or non-competes. How is that a part of it, or is it?
Yeah, I mean, non-competes and non-solicitation are more on the side of employment law. They really deal with communications with employees that leave an organization and what they can and can't say to folks who remain inside that organization. So from a non-solicit perspective, you can't go and try to pull or entice other employees from where you're leaving. On the non-compete side, it's adjacent to IP in the sense that the idea is you have developed some level of knowledge, that is unique to an industry. And if you were to leave a company in the same industry and go to another company that is a competitor, you may take that knowledge with you into the competitor shop and use it in a way that is detrimental to the company that you're leaving. So it's adjacent to IP because it does deal with know-how, and there are some rules about what you can restrict from the perspective of a person that is covered by a non-compete. So information that is derived from working within an organization, just as a result of you being there, you've developed a level of expertise. Typically, you're not supposed to prevent someone from leveraging their expertise in order to earn a living, especially if it's in like a market that's really small, like a duopoly. Going back to the Coke example, you get Coke and Pepsi, very large competitors. A non-compete that is so broad that would prevent any Coca-Cola executive from moving over to PepsiCo and not being able to leverage just their generalized skills as a lawyer or a scientist or a salesperson. Those would probably run afoul. And of course, this is not legal advice. You'd have to check with the lawyer. My experience has been those typically don't fly. But you can narrowly tailor non-competes in a way as long as they are short in duration and specific to, for example, the work that an individual has done while they were there. So if you were an amazing research scientist that came up with some novel containers that extend the life of sodas, you could potentially prevent that person from going to a direct competitor and working on the exact same stuff. They can still work as a scientist. They can work on other projects, but typically you could narrowly tailor in that way. To your point, there's been a push to change non-competes at a federal level. Some companies have gone too far with how they have sought to restrict the work of employees. And so the jury is still out.
Okay. I want to talk about the book, The Ethical Imperative, Leading with Conscience to Shape the Future of Business. Give me, from your perspective, kind of where this came from, what the intent.
Sure. So in 2018, I was the vice president and general counsel of UPS Airlines. Moved to Louisville, Kentucky, and started the role. I was positioned as, hey, this is an opportunity for you to take on senior leadership, large organization, 20,000 employees. And then COVID happened. And so I began journaling about the challenges that my team were going through and strategies for helping them to regain and retain high performance through that crisis. And I think it's a crisis for just about everyone. And so as I was doing research into like strategies that executives had used in the past, what I realized was that there are really four moral imperatives that any leader has to really focus on. And that's the first is to work quickly, to move with speed. If you look at organizations prior to the 1970s, a lot of those organizations, and they were run by Silent Generation, Greatest Generation, those organizations tended to divest power closer to managers, closer to frontline supervisors, allowed employees to take a more active role in the decisions of the life of the organization. And so that's where this concept of speed as a moral imperative comes from. It actually relates to our topic of intellectual property because the rate of innovation of an organization says a lot about its speed. Slow organizations tend to be less innovative. They tend to not engender or encourage the types of ideas from their employees that allow them to be avant-garde, to allow them to be at the front of the pack. And it shows in the number of patents that they file, many other ways. The second moral imperative is really to lead with inspiration, to connect the work that we are doing to some benefit to the world that is a goal that we can all share in. Organizations like Coca-Cola and their work on water replenishment, organizations like Bombas and their work on providing socks to the homeless. These are critical pieces of the employee engagement puzzle, really. It's a puzzle that we have to solve. And so when I was working through the pandemic, I realized that by being a part of Operation Warp Speed, that was the Trump administration's push to deliver medicines and vaccines around the world, it gave our employees a North Star. It was something that said, hey, we are part of a movement to save the world. The whole idea, the slogan, it's a patient, not a package, was really motivating during that time. The third moral imperative is community investment. Again, going back to organizations prior to the 1970s, what we found were organizations that invested in communities heavily. So Hershey, Pennsylvania would not be a place without Hershey. Bentonville, Arkansas would not be a place without Walmart. Coca-Cola, even Atlanta, would not be the type of place it was without Coca-Cola and Chick-fil-A and some of the other companies that have really opened up their organizations to addressing needs of communities. And what we find is that organizations that identify a place that they want to transform and go about a strategic vision in doing that, even if it's public or even if it's a public-private engagement or just a private movement, it doesn't matter. The outcomes of those communities tend to be better than, for example, places like Walterboro, South Carolina, where there's been economic distress for a long time. So the community investment becomes a really critical piece. And then finally, the last imperative is openness. Building open systems is really what inspires organizations, people within organizations, to do their best work when they believe that even if there are disappointments, I know that there's a level of meritocracy built in. I am being heard in the organization, that the leaders care about me in the organization. These key pillars of being an organization that's open makes employees perform better. What I have found just as an employee, sometimes there can be a sense that we are creating walls between each other where walls don't need to exist. And so when we segment ourselves rather than creating the places where we can connect, there's a different feeling. So building bridges, opening doors, creating places where people can connect and embrace shared humanity become really important. And I think a lot of it stems from my experience during the pandemic, because the truth is it seemed like the world changed. But the world didn't change. I think we changed. I think people, since we were all going through the same thing at the same time everywhere, people started asking questions like, do you really care about me? Does this organization care about me? I know the things that are really important to me now. They're things like family. And so we had this complete reset on the things that matter. And so what I'm bringing forward is that caring has to be first and foremost. And when you lead with caring, when you lead with systems that are welcoming, that create connections rather than create barriers, you tend to have more effective and high-performing teams.
Yes, that's huge.
I do want to go back a little bit to operationalizing some of the things that we talked about from the intellectual property side. How do I go about best practices in securing my intellectual property rights? A few pointers, a few strategies for small and medium-sized businesses. First, conduct audits. Regularly review and document the IP assets that are available to you. And, talk about patents, trademarks, copyrights, trade secrets, even designs, right? So patents come in utility and design flavors, designs, how something looks. So talk to your team, again, within the context of an open system, bring people together, regional whiteboarding sessions, actually going to folks who within your organization that have great ideas and say, hey, we want to just sit down and put some of these ideas on paper. That's the first step in going about securing those rights that you're looking to secure. And do it regularly, like if it's quarterly or yearly, that kind of thing, and keep a book. Sometimes in the old days, when I started practicing law, people would ask, hey, where's your IP book? Where's your patent book? And it's just a record of those ideas that have been captured. The second thing is to register your intellectual property. Now, there's some IP that you have protection from the minute that it's created. So, copyright, for example, you create a story say you're a content company and you have story writers, the minute that they put pen to paper and they create that story, there is copyright protection. But there are other ways of registering that IP. You can register a copyright once a work is completed with the Copyright Office. You can file a patent application to protect an invention. These are things that you should do because they create enhanced protections for you. Sometimes they are notice protections that puts the world on notice that you are the owner of this thing. And sometimes they're enhanced damages protection. So if someone does steal your IP or copies your work, you are able to get, sometimes 3 times the amount of damages as a result of you just registering your intellectual property. Thirdly, I really encourage small businesses to engage in NDA practice, and that's non-disclosure agreements. Create a standard non-disclosure agreement and use it routinely. Put NDA provisions in your employee agreements when they onboard and ensure that they're time-bound and they're reasonable. They relate to the work that the person is doing, not just with employees, but also with vendors. I should also say, when you have vendors, they're coming onto your property, make sure vendors have NDAs because, your vendors walking through, people might have confidential information sitting on tables or desks. And it's very easy these days to just snap a picture with your cell phone of confidential information. So make sure that your NDAs are in place and are protecting your information in that way. Monitor and enforce your IP rights. An IP right is no good if it is not protected and enforced. So if you have copyrights, ensure that you are sending cease and desist letters when you believe someone is infringing, that you are engaging with competent counsel that can negotiate either the takedown of things that are infringing. Ensure that you are looking and policing, because what ends up happening is there's a theory in the law that, if you don't protect your rights, you lose your rights. So if you, for example, know that someone is infringing your trademark and you don't do anything to enforce it, well, if you go for a sufficient period of time without doing it, you may lose some protections. So really look at monitoring enforcement programs. The last 2 things I would say. 1, educate your employees. So training employees on the importance of IP and best practices in protecting it can go a really long way to ensuring that you have a strong brand in the minds of consumers and that you're also keeping the value high on your products and your confidential information, your data, your systems. We at UPS, when I was working there, had routine trainings on this stuff. It also goes a long way in just ensuring that people know when they have created something that's worthy of protection. And I've seen this many times. You've got people out in the field, they're working in an operating environment, a warehouse or a factory or something. They come up with some fix to a problem that is just a practical fix because they are, necessity is the mother of all inventions. They have created a unique, efficient way of doing it, and nobody knows about it except 2 or 3 managers inside that factory. And it could be a solution that every factory could use and create economies of scale. And we just don't know about it because employees aren't educated in who to contact when they come up with something that's good like that. And I guess the last thing I would say is implement security measures. Use technical measures like encryption and access controls to safeguard your IP and your data. This is really important when it comes to trade secrets, because trade secrets, if they're not protected, they can be lost. Typically, if you lose a trade secret, the damages are so incalculable, they really can't be recovered, because the idea is only a few people know the trade secret. And if more people know the secret, then is it valuable anymore? The ultimate trade secret many people think about is like the Coca-Cola formula for Coca-Cola, right? At UPS, we also had a system called Orion. It's the reason UPS package cars only make right turns. Wait,
are you allowed to talk about that? Did you sign an NDA?
No, I cannot tell you why UPS package cars only make right turns. But there's really important safeguards that you can put in place to protect that kind of stuff. Creating processes that block access to things that are critical to the organization are important for the value of the IP itself. and your ability to recover if anything happens as a result.
Super helpful. This is fascinating. Does it get old to you?
No, it doesn't. It doesn't get old because every single day people are creating new and amazing things. That is our nature as human beings. We're tinkerers by nature. And as a result, I will always have a job. So I'm very grateful for that. But we are also very greedy as humans. We want to protect those things that we create. We want to generate value from them. And so that also is a motivator. I know many companies that provide cash incentives to their employees when they come up with great ideas or they get a patent. There's also the ability to generate revenue as a result of just having intellectual property. So there are companies that do nothing but license the things that they have created. So there's the licensing revenue that can come from it. And of course, from a trademark perspective, just the mere fact that, there are brands, if you see their logo, that it's going to be a huge check associated with it. Creators across all industries are starting to realize brand value as being really, really important and something that can bring a lot of financial reward. So I continue to be enamored with the field that I'm in, with the revolution in AI. We are seeing a new burst of creativity and innovation happening. And that is also very interesting to see how things are developing and changing in such rapid succession. There's a book by a man named Azeem Azhar. It's called The Exponential Age. And he talks about how we are moving so fast that society will almost be unrecognizable 15, 20 years from now. We'll look back and say, my gosh, do you remember when we didn't have tires that don't have air in them? And do you remember when we had cars that were combustion? We don't have cars with combustion anymore. I mean, heck, I can remember back when I was a kid and I had, one of those floor set TVs with the antennas sitting on top and everything was kind of analog and grainy. And now, my computer screen is 3 times as efficient and clearer. And, it's just things are changing rapidly for us. And that also just makes the practice of IP law very exciting.
Well, your excitement and passion for it definitely comes through. This has been super interesting. Thank you so much.
Absolutely. It's my pleasure. And thank you very much.
If you enjoy this podcast, please make sure to subscribe. And to stay updated on everything that the Action Catalyst is up to, make sure to follow us on Facebook and Instagram at Action Catalyst Podcast and on Twitter at Catalyst_Action. And as always, thanks for listening.